Hi, I'm Haley, and this is me describing chapters 5, 6, 7, and 8 of Legal Argument for Legal Reasoning. So, instrumental reading is fast, it's efficient, it's kind of just scanning over a text, but it's not doing a deep dive into anything. Instrumental reading is useful when you already know what you're looking for, like if you're looking for a definition or just something specific in a text. But on the other side, you can also easily misunderstand something if you take something out of context. And then contrary to instrumental reading, active reading is mindful, it's careful, and you're kind of treating every word as important and deep diving into everything. If you are active reading, then you're constantly asking why in an argument, like why is this way, why is this way? It's not like your normal thought process. You're also constantly checking sources for facts, even if it feels like you don't have to. By that I mean you always want to make sure your facts are accurate and cited. Another big part of active reading is kind of looking to see how the other side would interpret what you're reading as well. So, like, how would the other side view the same type of language that I am? Lawyers should be combining both types of reading depending on what they're doing. This is because lawyers need to be efficient and they need to be careful. In Chapter 6, we went more in depth of the major premise. As we talked about in class, the goal of the major premise is to establish a rule of law with a judge or a jury. With this being said, you want to know who your audience is. You want to make sure that audience has no other choice but to side with you. By this, you can establish certainty through authoritativeness, as like the book says. Basically, you can use binding sources and non-binding sources. A binding source would be like the Constitution. If your major source rule of law like aligns with a binding source, then the jury or the judge has no choice other than to support or believe your major premise. And this is because the authoritative source already had accepted it. However, non-binding sources can also be just as convincing. These would be statutes and cases. And a good argument might use multiple sources of authority, so there might be some binding sources in there, and there also might be some non-binding sources. And you want to make sure you're grounding the major premise either directly or indirectly. To ground the major premise directly, you can quote statutes and interpret them, or you can also cite a case. But when you're citing either of these things, make sure the citation is directly following the statement or that you're using. You can also indirectly ground something through tests. A few of these include step analysis and factor analysis. If both of these do not fit into your argument, you can use implicit rules. Moving on to Chapter 7, it talks about the minor premise. Just like the major premise, you can establish the certainty through authoritativeness, and you do this by grounding facts and evidence. This can be done through affidavits, experts, and other sources. Just like the major premise, any evidence or citations must be cited directly after the text. Evidence can also be indirectly grounded in multiple ways, like multiple times. However, most lawyers will end up appealing to common sense. They do this in one of two ways. The first is just making an inference based on facts. So, like, for instance, I'm wearing a coat so everyone can infer that it's cold out. And then the other way would be to make factual assumptions about the world to interpret a law a certain way. So the book uses a warrant, for example. Basically, you need a warrant based off of an expectation of privacy, as they say. So based on standards that we've made in our own society, we don't deem a car a granted place for a warrant. But you would need a warrant to go into someone's house, and that's based off of our own common sense based on values that we've made in our world. And then the other way to establish certainty is through content, and the content is made out of brute facts rather than compound facts. Brute facts are simple facts. They're stuff that don't really need any more explanation. So the book uses I have a headache as the example. If I told someone that I have a headache, they're probably not going to tell me that I don't have a headache. It's just something that you're going to believe. A compound fact, on the other hand, takes a fact and then it infers something else based on that fact. So the book uses the example of someone cheating on someone else. So someone's holding hands with someone and then I'm going to infer that they're cheating, but the original fact would be just that they were holding hands. Brute facts are just intrinsically more persuasive because the only way that they're not true is if someone's lying about something. Compound facts are a little bit less persuasive because there's multiple reasons why it might not be true. Like the cheating example, everyone has different definitions of cheating, and therefore you might not believe what I'm saying because you don't have the same definition of cheating. So with that information, you want to take your compound facts and break them down into brute facts. This makes it way more persuasive to your audience. Another thing that you want to do to make your argument more convincing is to elaborate on key legal terms. So you're going to take any term that's not self-explanatory, or you want to take like the common term of a premise and elaborate. By elaborating, you want to ground them in a new syllogism. So let's say you're making a syllogism or an argument about highway safety. You want to define what highway safety is in like a new syllogism. Advocates fail because they don't back up these syllogisms. They think it's obvious or self-explanatory, and it's not always. To avoid this, you always want to use the why test. So like, why is it this way? Why is it this way? In Chapter 8, just goes over all of the steps that I just talked about on how to make a legal argument.